All right, Monday and Tuesday of this week, the Supreme Court handed down a stack of rulings before heading into summer recess. And buried in that stack was a defeat big enough to undo one of the very first things Trump did on day one of his second term: 6 justices against 3. His own attorney general's office on the losing side of the argument. And a dissent so sharp, one justice warned it would trigger, in her words, chaos going forward. Let's get into exactly what happened and why this one actually matters more than most Supreme Court stories do. Quick context. On the very first day of his second term, Trump signed an executive order attempting to limit birthright citizenship. The rule, straight out of the 14th Amendment, that says anyone born on U.S. soil is automatically a citizen, regardless of their parents' immigration status. That's been the law for over a century and a half. Trump's order would have carved out an exception. Babies born in the U.S. wouldn't automatically get citizenship unless at least one parent was already a citizen or permanent resident. Lower courts blocked it almost immediately, the same day it was signed. It never actually went into effect. But Trump's team fought to keep it alive all the way up. And in April, something unusual happened. Trump personally showed up to the Supreme Court to watch the oral arguments in person. First sitting president in history to do that for his own case. This past Tuesday, the answer came back. 6 justices to 3. The court ruled the order unlawful. 5 of those 6 justices grounded their reasoning directly in the text of the 14th Amendment itself, the plain language that says anyone born or naturalized in the United States and subject to its jurisdiction is a citizen. The 6th justice in the majority, Brett Kavanaugh, a Trump nominee worth noting, agreed the order had to fall, though he framed it slightly differently, saying it violated federal law rather than the Constitution directly. Either way, 6 votes against the order, it's dead. Trump's response came fast, and it wasn't quiet acceptance. He posted publicly that the ruling was, in his words, too bad for the country, but said the fight wasn't over. His plan now is to push Congress to pass the same restrictions through legislation instead of an executive order. Here's the problem with that plan, and it's not a small one. With the current makeup of Congress, that bill has essentially no path to passage. Trump himself seemed to acknowledge the order was legally settled, even while framing the loss as just a bump in the road. He specifically said no constitutional amendment would even be necessary, just legislation, which, again, isn't realistically happening with this Congress. Now, here's where this story actually gets its edge, because it wasn't the only major ruling that week, and the pattern across all of them is what's worth paying attention to. The same week the court struck down the birthright citizenship order, it also ruled on Trump's attempt to remove a sitting Federal Reserve governor, Lisa Cook. Trump had cited unproven mortgage fraud allegations Cook has denied, as his justification for trying to fire her at a moment when he's been publicly pressuring the Fed to cut interest rates. The court blocked that removal, permanently for now. No president since the Federal Reserve was founded back in 1913 has tried to oust a sitting Fed governor this way, and the justices made a point of emphasizing why the Fed's independence from direct presidential control matters as a structural safeguard for the economy. But it wasn't a clean sweep against Trump. In a separate case, the court actually ruled in his favor, 6-3, on a different question entirely: his authority to remove members of independent federal regulatory agencies without giving a reason. That case centered on his firing of a Democratic member of the Federal Trade Commission, and the ruling expanded presidential power over independent agencies significantly, overturning a legal precedent that had stood since 1935, protecting regulatory leaders from being fired at will. Trump celebrated that one loudly, calling it one of the most important rulings on presidential power in history. So line those 3 rulings up together, and you get the real shape of this week: a win on regulatory agency firing power, a loss on Fed independence specifically, and a major loss on birthright citizenship. 3-1, essentially, going against him on the 2 biggest and most personally invested fights. Let's talk about the dissent, because it's worth hearing in its own right rather than just as a headline. Justice Sonia Sotomayor wrote the dissent in the FTC case, the one Trump won, and she didn't hold back. Her core argument was that the majority had thrown out 90 years of settled, workable legal practice in favor of what she called a half-baked theory of executive power, one that's simultaneously sweeping in scope but riddled with vague, undefined exceptions. Her closing line was blunt. The one thing that seems clear going forward is that chaos will follow. That's a sitting Supreme Court justice in a published dissent, using the word chaos to describe where she thinks this leaves federal regulatory law. Reactions split predictably down political lines, but a couple of responses are worth actually hearing rather than summarizing. Democratic Senator Elizabeth Warren argued Trump has been systematically removing independent officials and consolidating control over agencies that were designed to answer to the public rather than to him personally. On the other side, Trump framed the regulatory power ruling as a historic validation of presidential authority, and some of his allies in Congress signaled they're already looking at the birthright citizenship result as a rallying point heading into the next legislative session, even while acknowledging privately that the votes aren't currently there. New York Mayor Zohran Mamdani weighed in on the birthright citizenship ruling specifically, without naming Trump directly, framing it as a reaffirmation of a promise written into the Constitution over a century and a half ago, that anyone born on American soil belongs here, regardless of background. Several House Democrats issued similar statements, tying the ruling to the country's approaching 250th anniversary and framing it as a rejection of what they called an exclusionary vision for the country. Now, let's be fair to the other side of the birthright citizenship argument, because there is a real legal debate underneath the politics, even if this particular case settled it decisively for now. Supporters of the original order have argued for years that the 14th Amendment's citizenship clause was originally understood in the context of freed slaves after the Civil War, not as a blanket rule intended to cover every possible category of birth circumstance, including children of people in the country without authorization or on temporary visas. That's a genuine, decades-old legal argument with real scholarship behind it, even though it's a minority position among constitutional law experts and has now lost decisively at the Supreme Court. It's not a fringe theory invented for this case. It's an argument that's been circulating in conservative legal circles for a long time, and this was its biggest test yet. It lost, clearly, but the underlying disagreement about how to interpret the amendment's original scope hasn't disappeared just because this specific order was struck down. It's also fair to note the Kavanaugh angle specifically, because it complicates the court unanimously slapped this down framing you might see elsewhere. He didn't sign onto the broader constitutional reasoning the other 5 justices used. His narrower path, ruling the order violated federal statute rather than the Constitution's text directly, theoretically leaves a sliver of room for a differently constructed future effort, even though, practically speaking, that's a very narrow needle to thread, and most legal observers don't expect anyone to seriously try. So what actually happens next? Legally, the birthright citizenship order is dead, struck down, not sent back for revision, not paused pending further litigation. It's over. Politically, Trump has said his next move is legislative, but as already covered, that's not realistic with the current Congress, which means this is likely to become a talking point and a campaign issue rather than a live legal threat anytime soon. On the Fed independence ruling, that one's now a fairly firm precedent protecting the Fed specifically, even as the broader regulatory agency ruling from the same week cuts the opposite direction for other agencies, which is exactly the kind of contradiction Sotomayor's dissent was warning could create confusion going forward. The Supreme Court is now heading into its traditional summer recess, back in session this October. Nothing more from the justices themselves until then. But the political fallout from this week, 3 major rulings, a mixed record, a furious dissent, and a president publicly vowing to keep fighting a case he's already lost. That part isn't over at all. It's just moved out of the courtroom and into Congress and the campaign trail, which is exactly where these fights tend to get louder, not quieter. Here's the honest bottom line. This was one of the most consequential weeks for presidential power in recent Supreme Court history, and it cuts in genuinely different directions depending on which case you're looking at. Trump gained real, lasting authority over independent regulatory agencies. He lost decisively and permanently on birthright citizenship. He lost, at least for now, on Fed independence specifically. Anyone telling you this week was a clean win or a clean loss for him isn't giving you the full picture. The actual record is mixed, and the dissent from the court's own bench says the long-term consequences of even the win are genuinely uncertain. I'll be watching how Congress responds to Trump's push for birthright citizenship legislation, because that's the one thread from this week that's genuinely still open. The one he couldn't fire, inside Trump's failed takeover of the Federal Reserve. Trump has fired members of federal agencies before and gotten away with it, cleanly with the Supreme Court's blessing. Just this same week, in fact, the court let him remove a Federal Trade Commission member without a second thought. But there's one person in his entire administration's crosshairs he has not been able to touch, not for lack of trying. And the reason why says a lot about which parts of the federal government the court is actually willing to let a president fully control, and which parts it isn't. Her name is Lisa Cook. She's a member of the Federal Reserve's Board of Governors, the body that sets U.S. monetary policy, decides on interest rates, and is designed by law and by decades of tradition to operate insulated from direct presidential pressure. She was nominated by President Biden back in 2023, and she's the first Black woman to ever serve in that role. Since taking her seat, she's consistently voted alongside Fed Chair Jerome Powell, including on decisions to hold interest rates steady in the aftermath of the inflation surge that hit the country in the early 2020s. Here's where this turns into a legal fight. Back in August of last year, Trump publicly posted a letter announcing he was firing Cook. His stated reason, allegations that she'd committed mortgage fraud back in 2021, years before she ever became a Fed governor, first raised by a Trump-appointed housing official named Bill Pult. Cook has consistently and firmly denied the allegations, calling them flimsy, unproven, and, in her words, conveniently timed right after she and the rest of the board declined to bow to the president's public pressure for rate cuts. It's also worth knowing that several news organizations have since reported that financial documents connected to the case appear to actually undercut the fraud claim rather than support it. Cook didn't just accept the firing. She sued immediately. Her argument was straightforward. Under the law that governs the Federal Reserve, a governor can only be removed for cause, meaning there has to be an actual, legitimate, job-related reason, not just a president's say-so. Cook argued the mortgage allegation wasn't real cause, and that even if it were, Trump skipped the legal process she was owed before removal. A federal district judge agreed with her within weeks and blocked the firing while the lawsuit played out. Trump's team tried to get an appeals court to let the firing proceed anyway while the case continued. That failed too. So it went to the Supreme Court, and the case became a genuinely big deal well before the ruling came down. Fed Chair Jerome Powell himself showed up in person to watch the oral arguments in January, an unusual move, and he later called it perhaps the most important legal case in the Federal Reserve's entire 113-year history. That's not a stray comment. That's the head of the U.S. Central Bank telling you on the record how much weight this case carried. This past Monday, the ruling landed. 5 justices to 4, the Supreme Court sided with Cook, at least for now. She keeps her job while the underlying lawsuit continues. Importantly, the court didn't rule on whether Trump can ultimately fire her once the full case plays out. This was specifically about whether he could remove her immediately, while litigation is ongoing. But procedurally, that's still a real win for Cook and a real defeat for the administration's attempt to install someone more compliant on the board right now. Chief Justice John Roberts wrote the majority opinion, and one line from it is worth hearing directly because it lays out exactly what the court thought was at stake. If the administration's argument had been accepted, Roberts wrote, it would effectively turn the Fed's for-cause job protection into ordinary at-will employment, meaning a governor could be fired for essentially any reason at all, which he said would be completely out of step with both the actual statute Congress wrote and the country's long tradition of keeping central banking decisions insulated from political interference. Here's the detail that made this ruling genuinely surprising to a lot of legal observers. The coalition that formed the majority wasn't the usual ideological lineup. Roberts was joined by Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson, the court's more liberal wing, but also by Brett Kavanaugh, a Trump appointee himself. During oral arguments, Kavanaugh reportedly pushed back hard on the government's own lawyer, warning that letting a president fire Fed governors for cause without any real judicial check would, in his words, weaken, if not shatter, the Federal Reserve's independence. When a justice appointed by the very president bringing the case raises that kind of alarm, that's a signal the argument wasn't landing even with sympathetic ears. And here's the part that makes this ruling stand out from everything else the court did that same week. In a separate case decided the exact same day, the justices went the other direction entirely. They let Trump's firing of an FTC commissioner, Rebecca Slaughter, stand, and in doing so, overturned a nearly 90-year-old precedent that had protected independent regulatory officials from being removed without real cause. Roberts wrote both opinions. Read side by side, his reasoning draws a very deliberate line. Agencies like the FTC exercise power that ultimately flows from the president and should answer to him. But the Federal Reserve is different. Different structure, different history, different purpose. And that difference is exactly why it gets stronger protection. The court essentially carved out a Federal Reserve exception to its broader pattern of expanding presidential firing power. Same week, same Chief Justice, two opposite outcomes because the court decided the Fed genuinely isn't like other agencies. Cook responded to the ruling in a public statement that's worth hearing in full context. This was never about mortgage documents signed years before she became a governor, she said. It was an attempt to remove her over a manufactured pretext because she refused to bow to political pressure and kept setting interest rate policy based only on what would best serve the American people. She called that the single most fundamental obligation of a Federal Reserve governor and said the ruling reaffirms a bedrock principle that's guided the Fed since its founding. That policy decisions have to be made on evidence and independent judgment, not political interference. Now, let's be fair to the other side, because this administration's argument wasn't just posturing. There's a real legal theory underneath it. The core claim was that under the Constitution, all executive power ultimately belongs to the president, and that includes broad authority to remove officials who exercise that power on his behalf, without much room for courts to second-guess his stated reasons. That's not a fringe idea. It's the same reasoning that won the FTC case that same day, and it reflects a genuine, long-running legal debate about how much insulation Congress can constitutionally build around executive branch officials. The administration's lawyers argued a president needs real authority over anyone implementing economic policy, especially given how directly Fed decisions affect the country he was elected to lead. That argument persuaded 4 justices in this case, and it's the same reasoning that carried the day entirely in the FTC ruling issued hours later. It's also worth noting Bill Pult, the official who originally raised the fraud allegations against Cook, hasn't backed down. After Monday's ruling, he posted publicly that he still believes Cook will ultimately be indicted for mortgage fraud, separate from this civil litigation entirely. That's a real live thread. A criminal referral exists, apart from the employment lawsuit, and it hasn't been resolved by this week's ruling one way or the other. So what's actually settled and what isn't? Settled. Cook keeps her seat on the Fed board for now, and Trump cannot remove her while her lawsuit proceeds. Not settled. Whether Trump can eventually fire her once the underlying case reaches a final decision, this ruling was specifically about the emergency immediate removal question, not the ultimate merits. Also not settled, the separate criminal allegation Pult has referred to the Justice Department, which exists on its own track regardless of what happens with her Fed seat. Senator Elizabeth Warren, a longtime critic of Trump's pressure campaign against the Fed, called the ruling a rebuke of both the president and Pult specifically. That's a political read, obviously, from someone who's been vocal on this issue for a long time. But the underlying fact she's pointing to, that the court explicitly rejected the administration's attempt to remove Cook on an emergency basis, is accurate, regardless of how you weigh the framing. Here's the honest big picture. This is genuinely one of the most significant Fed-related legal rulings in modern history. And it landed the same week the court handed Trump real, lasting power over other independent agencies. That combination tells you something specific. The justices aren't drawing a blanket line either fully for or against expanded presidential control. They're drawing it very deliberately around the Federal Reserve specifically, treating monetary policy as different in kind from other regulatory functions. Whether that distinction holds as this case moves toward a final ruling on the merits is the actual thing worth watching next. Powell called this the most important legal fight in the Fed's history for a reason. And even after this week, it's not actually over. It's a real live thread. A criminal referral exists, apart from the employment lawsuit, and it hasn't been resolved by this week's ruling one way or the other. So what's actually settled and what isn't? Settled. Cook keeps her seat on the Fed board for now, and Trump cannot remove her while her lawsuit proceeds. Not settled. Whether Trump can eventually fire her once the underlying case reaches a final decision, this ruling was specifically about the emergency immediate removal question, not the ultimate merits. Also not settled. The separate criminal allegation, Pult has referred to the Justice Department, which exists on its own track regardless of what happens with her Fed seat. Senator Elizabeth Warren, a longtime critic of Trump's pressure campaign against the Fed, called the ruling a rebuke of both the president and Pult specifically. That's a political read, obviously, from someone who's been vocal on this issue for a long time. But the underlying fact she's pointing to, that the court explicitly rejected the administration's attempt to remove Cook on an emergency basis, is accurate, regardless of how you weigh the framing. Here's the honest big picture. This is genuinely one of the most significant Fed-related legal rulings in modern history. And it landed the same week the court handed Trump real, lasting power over other independent agencies. That combination tells you something specific. The justices aren't drawing a blanket line either fully for or against expanded presidential control. They're drawing it very deliberately around the Federal Reserve specifically, treating monetary policy as different in kind from other regulatory functions. Whether that distinction holds as this case moves toward a final ruling on the merits is the actual thing worth watching next. Powell called this the most important legal fight in the Fed's history for a reason. And even after this week, it's not actually over.